He had a short stint of 3 years and 9 months, but in his tenure, he delivered some landmark rulings on personal liberty, on pre-trial detention, and environment protection. He not only spoke vocally, or he was not only vocal in the court, but also spoke strongly through his judgments. Today, we are joined by former Supreme Court Judge Justice Abhay Oka. Thank you so much, sir, for joining us. And we really look forward to having a candid conversation with you with regard to your career as a judge, which I think spanned for more than 2 decades, and also your stint, as I just pointed out, small though, but your stint as a Supreme Court judge. So I'll begin this interview with something which is very topical since you are from the Bombay High Court, that is your parent High Court. So Bombay has recently seen the addition of another bench, which is in Kolhapur. And I think with the addition of this bench, now Bombay High Court will have 4 benches. Do you think it is proper for one particular state to have 4 benches? And do you think that this could even give rise to demands by other bar associations, for instance, in UP, where the demand to have another bench has been there for many decades, but unfortunately it has not been looked into?
In 1985, Government of India appointed Justice Jaswant Singh Commission consisting of 3 members. Jaswant Singh was retired judge of the Supreme Court. The commission was supposed to address on very issue, and there is a very detailed report of 1985 of the commission which lays down the criteria for establishing additional bench. That was in 1985. Talking about Bombay High Court, in 1997 there were demands for establishing a bench at Pune, Kolhapur, Solapur, I think Akola, if I mistake not. Bombay High Court appointed a committee of judges. Committee in depth considered the entire issue. By that time there were 3 benches. Committee considered the issue. Committee applied the criteria laid down by Jaswant Singh Commission and ruled that there should not be any additional bench. And that committee report was placed before the full house of all judges. By substantial majority, report was accepted. So decision of the full house is that no more benches. Firstly, I deal with Kolhapur aspect.
Yes.
So Kolhapur demand was considered by the full house and said that
no
additional bench, neither Pune nor Kolhapur nor any other place. Then in, I think, 2006, again there were demand from Kolhapur. Administrative Committee of the High Court consisting of the Chief Justice and 2 senior most judges said that no departure from the earlier decision of 1997, that was a full court decision. Then thereafter one more committee was appointed, 2013. Committee could not take any decision. 2017 one more committee was appointed. In 2018 and 22, respective Chief Justice gave hearing to Action Committee of Lawyers from these 6 districts which are under the jurisdiction of Kolhapur bench. But no decision was taken to establish a bench. Under Section 51(3) of the States Reorganization Act, power has been exercised by the Chief Justice. It is the power of the Chief Justice. But in the facts of the case, there is a binding resolution of the full house. Chief Justice is bound by that. Therefore, Chief Justice, without putting the issue before the full court, could not have done it. So propriety demanded that it should have gone to the full court. And then full court would have been required to do the same exercise which are done by earlier committee in 1997. So first issue should have been before the full court, whether there should be at all additional bench, whether it is viable.
Whether it is viable,
Because there are financial consequences. It requires huge investment. There will be a huge complex now. Not only court complex, you need to provide staff, you need to provide IT infrastructure, you need to provide cars, bungalows for judges, staff quarters. It's a huge thing. So whether 4th bench is viable, that should have been the first issue. If answer to that question given by the full house after doing this elaborate exercise applying criteria of Jaswant Singh was that additional bench is possible, then they should have fixed rational criteria. There are conflicting demands from Pune, then Kolhapur,
Okay.
Solapur.
Okay.
And after fixing the criteria, if Kolhapur satisfied that criteria the best, it could have been at Kolhapur, it could have been in Solapur, it could have been at some other place.
So basically, the Chief Justice should have looked into the demands of the other bar associations before taking a decision with regard to Kolhapur.
And he
Is
should have
that-
gone before the full house.
It should have gone before the
Because
full
he
house.
can't overrule decision of the full house, he is bound by it.
Okay.
So that's on decision making process.
Yeah.
Now Kolhapur has been established, it started working. I have said in one of my articles that now there is no question about setting the clock back. The larger issue now. When Jaswant Singh Commission gave a report, at that time nobody had heard video conference hearing or e-filing. Perhaps the facilities of transport were also not that modern. Now we have Vande Bharat trains, more airports, better connectivity of roads.
You're right.
So considering the situation in 1985, the criteria was fixed. Now this issue is going to arise pan-India because bigger states like say Madhya Pradesh has 2 benches.
That's right. Yeah.
Right. So bigger states are going to raise this issue.
Yeah.
And Bombay has a different thing again. Nagpur was already a high court.
Okay.
After it was principal seat of Madhya Pradesh High Court, Madhya Bharat High Court. So Nagpur became a bench. It was already there. Goa, we had a judicial commissioner's court, which was converted into high court. And now Bombay High Court is common high court for 2 states, Maharashtra and Goa.
Okay.
So
Yes.
it's hardly a bench now. It is part
Okay,
of the
it's
common
part
high
of the
court.
common, yeah.
And Aurangabad bench, it is stated in the judgment of the Supreme Court that in 1953-54 there was a pact known as Nagpur Pact. So all politicians were parties to that, and it was agreed in Nagpur Pact that large area, Marathwada area we call it, that was added to Bombay state at that time from Hyderabad state. So that area should be given
So there was a
bench,
need at that point of
bench.
time.
And that is written in that Nagpur Pact. And Supreme Court has relied upon Nagpur Pact while affirming the decision of the Chief Justice. Now pan-India this issue is going to arise. Therefore really now the need is to lay down the norms, lay down the criteria. Now first issue is the same issue, whether now there should be additional benches at all.
Yeah.
Because today we have crisis in the sense that we are not able to provide proper infrastructure to common man's courts like
Yes.
trial courts, district courts. So need is to actually give proper infrastructure to those courts, increase the judge strength,
Yes.
at least make it 50
Yes.
per million. We have only 21.
Yes.
So that should be one priority. In the context of this priority of giving priority to the common citizens courts and availability of now these scientific methods like
Yeah.
video conferencing, e-filing, then whole thing must be given a relook. Maybe some commission can be appointed, maybe Supreme Court can lay down norms on the judicial side.
So basically, just to understand what you're really saying is that instead of having a multiple or a different bench for high courts, as is being, as the demand is being raised in different states as well, what the government or the judiciary should be really looking into is to implement the technology in a much inclusive manner so that the justice delivery system becomes better, it becomes improved. And instead of creating benches, additional benches, the trial courts need to be well equipped infrastructurally.
Exactly.
Because trial court continues to be the first point as far as the litigant is concerned. So, but that's the question which I wanted to ask. Why is that the trial courts in our country continue to be in dilapidated state? What is the reason? Because it's the state governments that are responsible for it as well as the state high courts. So why is this segment in the judicial setup being ignored?
See, there was order of 2002 of Supreme Court which said that just to population ratio in India should be 50 per million within 10 years. So by 2012 it should have been 50. In 2015 or 16 there is an order of the Supreme Court which is based on NCMS committee report headed by Professor Mohan Gopal. That Supreme Court laid down a formula that how to calculate ideal judge strength.
Right.
Every high court was directed to calculate the judge strength and submit a proposal to the government to create the post.
Yeah.
Speaking about Maharashtra, I was chairman of the case management committee. If I am correct, I remember correctly, our proposal in terms of the formula laid down by the Supreme Court was to create 8,000 more posts.
Just in Maharashtra
Maharashtra.
itself.
And I'm told out of 8,000, only 700, 800 are created. Because creating posts is also not easy.
Right.
You must have corresponding infrastructure. So Supreme Court says in 2002, let us have 50 as just to population ratio. Today it is around 23. So this is where we must go at the grassroots level and revamp those courts.
So is it that the judiciary should be taking the first step, or is it that we should expect the state governments to get into...
Now, judiciary, in terms of directions of Supreme Court, all high courts have submitted proposals to the state government.
Yeah.
It is for the state governments to act. Because law is very clear. It is the constitutional and legal duty of every state government to give proper infrastructure to the judiciary. The money comes from the state.
Okay. Okay.
We can't create posts. Sitting in the High Court,
Right.
we can't create posts.
Right. Right.
The posts have to be created by the government. The salary comes from the government. Infrastructure comes from the government.
So it has to be a joint effort of the state government as
Right,
well as the
right.
judiciary.
And therefore, now we must relook at the issue of creating additional benches.
Okay. High court benches.
So there has to be some consistency in approach
Right.
all over India.
Right.
So what should be whether it is necessary to have additional benches is the first issue. If it is necessary, what should be the criteria, where it should go?
Right.
See, political demand of the lawyers can't be the sole criteria.
Right. Got it.
Because there are remote places.
Yes.
Now, people in remote places may not make that demand.
Yeah.
Ultimately, access to justice is the real principle.
Sir, from your remarks with regard to Kolhapur bench, what you just told me was that, the Chief Justice took a unilateral decision with regard to the Kolhapur bench. So my second question actually revolves around the role of a Chief Justice. I want to specifically ask you with regard to the Chief Justice of India. There has been a lot of debate about the Supreme Court being CJI-centric. All of us know that all the judges of the Supreme Court are equal when it comes to, their rank. But still, there's a lot of power which is wielded by the CJI, and this was, the major cause of concern when in 2018 4 judges for the first time did a press conference where they objected to allocation and listing of certain cases before a particular bench. So basically the CJI, why is a CJI centric court, Supreme Court is a CJI centric court, is because the CJI is the master of the roster. You've been in the Supreme Court for more than 3 years, a little less than 4 years. What is your view about it?
Firstly, you said that Chief Justice of Bombay High Court took unilateral decision. I'll amend it slightly. I will say that he was bound by the decision of the full house. And the decision-making process adopted by him is flawed.
Okay.
Because we don't know whom he consulted.
Right.
That is not on record.
Right.
But the decision-making process is flawed.
Right.
Now, coming to lastly, you said about the interview by the 4 judges.
Yeah.
I have my own views about it. I feel that when you are part of the judiciary, you should not go to media and give interviews. Then your duty is to request the Chief Justice to call full house meeting. Otherwise, also there are full house meetings for some reasons. You can speak about it. I don't think going to media was the correct approach. I don't know what was the thinking process by 4 judges. As far as I'm concerned, I would not have done it. Because I believe that sitting judges should not talk to media, which I followed best possible extent. When I said Chief Justice centric court, I had 2 issues. One is the roster. In high courts, there is a fixed roster. When a litigant files a case, he knows before which bench his case will go. Roster is for 2 months, 3 months, 4 months, depends on the high court. Even there is direction of the Chief Justice that in case a particular bench recuses, it will go automatically to a particular bench. That reduces manual intervention in the listing. And I don't know earlier, at least what I have seen is there is no such roster in the Supreme Court. The subjects are fixed for benches, but those subjects are common in different benches. So there is a lot of discretion for manual intervention of the registry. Whether it is done by registry or Chief Justice of India, I can't say because Chief Justice of India hardly has time. I mean, such a onerous responsibility he has. That was one aspect of that. Second aspect is about certain decisions being taken by the Chief Justice instead of placing it before the full House.
Yeah, on the administrative side.
On the administrative side. Because
Yeah.
when we say Supreme Court, it's a decision of the full House.
Okay.
Of course, Chief Justice is master of roster.
Yeah.
Roster has to be fixed by him. And assignment has to be made of cases only by him. Nobody else has any say. That's very clear. But decision making on the administrative side, either it should be through the committees appointed by the Chief Justice or through the full House. What I have seen is that was not being done. But I must say that during the days of Justice Sanjeev Khanna and subsequently present Chief Justice, I think that change, there is a change brought about. Now, many administrative issues are being discussed in full House.
Okay.
So that's the change. I can say that has happened
Yeah.
during last 6 months.
In fact, we also noticed that how in the last 6 months, earlier administrative decisions taken by a former CGI have been, taken back only after they were put before the full court, I think.
Correct.
Yeah, yeah.
Even
So that is the proper
decision
way.
to remove grass partition was
Yes.
by full House.
Full House, yeah.
Right.
So
there is a change which should be appreciated.
Okay.
But the first part has not changed. Perhaps I don't know. I mean, present, I can't comment what is happening today.
Got it, sir. Sir, you spoke about the fact that sitting judges should not speak, but after retirement they should. So let me just come to something which is being really talked about, very topical. This is with regard to the nomination of former Supreme Court Judge Justice Sudarshan B. Reddy as a vice president candidate by a certain group of the political parties. Now, interestingly, what has happened is that the Union Home Minister, Mr. Amit Shah, made a comment over his controversial judgment, which was delivered way back in 2011 on the role of Salwa Judum. And he had certain reservations over the judgment. Now, in response to his statement, former Supreme Court judges and High Court judges issued a statement criticizing the Home Minister or raising, showcasing their concern over the manner in which he criticized Justice Reddy. Now, again, in response to this statement by the former Supreme Court judges and High Court judges, another group of former Supreme Court and High Court judges have issued another statement not really supporting the Home Minister, but by saying that, Justice Reddy has now jumped into the political arena, and the Home Minister's remarks were with regard to his being a vice president candidate. Now, my first question is that do you think former judges should actually be entering the political arena or not? And second is that if at all you think they should, then should former judges be coming out and sparring over such an issue and making it into a public debate?
Right. First question first. My personal view is that judges should not contest elections for any post. But in the past, it has been done. Judges have contested the election of the president election and vice president's election. But that's my personal view. This should never happen. Because once you accept judicial office, when post-retirement, some constraints are there. That is number one. Number two, there is a comment about a judgment delivered by a candidate who happened to be Supreme Court judge at that time. Why I have endorsed one particular view is that after reading that judgment, my personal view is that interpretation made by the politician, Honorable Home Minister, is not correct. That's what my personal view is after reading the judgment. Therefore, I endorse that view. As far as I am concerned, I am only on interpretation of a Supreme Court judgment. Only because a judge is contesting election, nobody should try to improperly interpret the judgment.
Okay.
But I want to add rider also. As my judgments can be wrong, my view about interpretation of a judgment can be wrong.
Right.
And therefore, naturally, there is other point of view that Honorable Home Minister is right in interpreting. So, I look at it differently. I am not looking at it politically. I look at it this way, that there are two views about interpretation of the judgment delivered by the ex-Supreme Court judge. And I personally feel that we should look at this controversy only in
From that context.
that context. And as I said, judges should not be parties to these elections. That's my personal view again.
Got it. Yeah.
Somebody may say that even that personal view is wrong.
Yeah. Yeah.
Because in the past, judges have contested elections.
So basically, what you really mean to say is
Retired
that,
judges have become vice presidents.
yes. So having a public debate over a judgment, there's nothing wrong in that.
Correct.
Because you can have two sides to a judgment as
Correct.
well, two interpretations to a judgment as well.
I deliver a judgment, tomorrow somebody, even you can do that, and you can say that for ABC legal reasons, my judgment is wrong.
Yeah. Yeah.
And in Supreme Court, you can interpret the same judgment in different manner.
In fact, I was about to come to that as well, because we have often noticed, and in fact, we are noticing it very recently. It's kind of we are seeing it too much happening in the Supreme Court. You know how judgments are actually either being modified or they are being overruled, overturned by higher benches. So, what do you personally feel about this kind of a trend? Don't you think it leads to more confusion, especially for the high courts, to implement those judgments?
See, firstly, there is a law of precedents in place. It's very well settled law. A coordinate bench is bound by the decisions of the other coordinate bench. If bench strength is same, if the coordinate bench feels that a decision of coordinate bench is not correct, requires reconsideration, only option is to record that and refer the case to the Honorable Chief Justice.
Yeah.
With a request to Chief Justice, refer it to larger bench, and it is ultimately his discretion whether to constitute or not. This is number one. Number two, if somebody is aggrieved by the judgment, in such a case there is remedy of review. In a limited cases, there can be remedy of recall. And in the context of Supreme Court, there is a curative petition.
Yeah.
Only in limited cases, there can be modification, in the sense that if there is a factual error in the judgment, some factual error in the operative part, question of modification comes into picture. Otherwise, it's a review. There can be recall also. So, for example, if one of the parties is not heard by mistake or for whatever reason, the party which is not heard can apply for recall also. The third contingency it can be modified is, there is a judgment of a bench, some other case comes up before a larger bench, and that larger bench argument is that the view taken by the other bench is not correct, which is of a lesser strength. Then surely the larger bench can say that earlier view is wrong.
Yeah.
So this is the law.
Okay.
And I don't think that law of precedents can be violated. I don't think it should not be done.
But do you think it's being done?
See, again, we have to examine the case, because there are contingencies and contingencies. There are connected cases, or issue involving, the same issue is involved in two cases. One case goes to one bench, other case goes to other bench.
Yeah.
The reason may be same, that there is no fixed roster. There is a discretion.
Yes.
Possible.
Yes.
If there is a fixed roster, for example, if roster says that all bail applications under PMLA will go to a particular bench, so it will go before that bench. So sometimes it does happen that one bench deals with the case, but there is a connected case with the other bench, or a case involving the same issue. Then naturally Chief Justice has to club both the cases together. It can happen this way also, that one case, connected case, is before larger bench, the other case is before bench of smaller strength. So naturally the other bench, the case will go to larger bench.
Yeah.
So therefore and third contingency I must also tell you, somebody can go to the Chief Justice and apply for transfer.
Right.
But then Chief Justice has to hear the parties.
Yeah.
So this is the legal position. So therefore, when there is an allegation that case is withdrawn from one bench to another, we must look into the facts why it is done.
Okay. So maybe this situation can be, can be improved if we have, as you said, a roster system is there. If one particular judge or one particular bench is hearing, cases where that contain similar issues, so that there is no, I won't call it contradiction, but so that there are no two views taken with
Correct.
regard to
Inconsistent
one
views,
particular
as we call
inconsistent
it,
views should
right?
not be there. So let me come to again a very controversial.
And therefore, transfer of that case pertaining to dogs.
Yeah.
What I said, we don't know why it was transferred. But if legally transfer is not permissible, it is wrong.
Okay.
But we need to examine whether connected case was with the larger bench. I have not examined that. We need to examine the facts. But these are the norms on which case can be transferred, not otherwise.
I would like to draw your attention to again a very controversial order which was delivered by a bench in the Supreme Court. Where very stringent remarks were made against a judge of the Allahabad High Court. My first question to you is that should the senior judges be commenting like this, with regard to judges of the High Court? Because, this trend is very common even in the High Court, where High Court judges pass comments against trial court judges. And my second question, which is related, is that, of course, this statement or these remarks were made because the bench in the Supreme Court noticed that, the trend of converting civil cases into criminal cases is like pending, is like, growing in the Allahabad High Court. And this has been a concern expressed by the other benches of the Supreme Court as well. So my second related question is that why is it that the high courts of this country are unable to follow and implement Supreme Court judgments in letter and spirit? So the first question is whether senior judges should be passing critical remarks against high court judges or junior judges. And second is that where is the gap? Why aren't Supreme Court judgments being implemented?
First question, I'll answer it based on view taken by me in one of the reported judgments, where High Court passed strictures against either session judge or district judge, I forgot that, where the view taken by me, which again somebody will be justified in saying it is wrong. The view taken by me is that normally higher courts can criticize a judgment, find fault with the judgments, but not with the judge personally. If the court hierarchy finds that there is something wrong with the judge, they should not say in the judgment, because there is an administrative side.
Yeah.
It can be reported to the Chief Justice of India, or maybe if it is about a judgment delivered by a civil judge or a district judge, it can be reported to Chief Justice of the High Court. So that is to be taken on the administrative side. That is my personal view, that sitting in the court, we can criticize the judgment, but not the judge, because there are methods available to take up the issue that is on the administrative side. Now, not following judgments of the Supreme Court, yes, that is the grievance which I also heard. Maybe in some cases I have seen. In criminal matters, there is law laid down by the constitutional courts, which is binding. So many things turn on facts also, because fact situation in every criminal case is different. It's about applying the settled law to the facts of the case. And there sometimes judges can go wrong. Ultimately, you appreciate the facts, you read the FIR, you read the, say, charge sheet, if prayer is for questioning the charge sheet, and then you apply settled law. So when you decide on the basis of facts, you can go wrong, because then you wrongly read the facts, or your appreciation of facts may be wrong. But yes, there may be few cases where the law laid down by the Supreme Court is not followed, and then it has to be corrected.
I want to ask you another question with regard to the judgment delivered by the Supreme Court upholding the Anti-Money Laundering Act, which is the Prevention of Money Laundering Act. In fact, some of your orders have actually gone to some extent of diluting that particular judgment, which came under severe criticism because it has upheld, the powers of the Enforcement Directorate. And we have seen that how it has been alleged, actually, let me correct myself, it has been alleged that the powers of ED, are being misused. And this judgment of the Supreme Court, in a way, backed that. So, what is your view about the judgment? Of course, in through your orders you've spoken, we would like you to express it for our viewers as well. And secondly, do you feel that the judgment needs to be re-looked at?
About that Vijay's judgment, review is pending.
Yeah.
So I'll not offer any comment about it because review is pending, court is hearing it. Secondly, if somebody says that I had diluted the view taken by the three-judge bench, firstly, I must say that that was never any argument made before me. That is number one. Number two, as judge, I can go wrong. So somebody can pinpoint that exactly which judgment takes view which is contrary to principles laid down in that Vijay's case. So somebody had to pinpoint that this is the law laid down in three-judge bench judgment and this is where I have gone wrong. Is most welcome. I believe what I had done is, in one case I interpreted the schedule, and all other cases what I have done, of course it is again my impression, I may be wrong. What I have done is applied well settled law relating to bails while granting bail. Now, one well settled proposition of law is that if, in almost all cases, maximum sentence is 7 years. Only when predicate offence in the NDPS Act, it is 10 years. So, if there is long incarceration in the context of the fact that maximum sentence could be 7 years, if trial is not likely to commence or conclude in near future, law is very clear. Article 21 has to be upheld, unless, of course, it's a case where person is history cheater. So, I think endeavor made by me was to follow the existing law when it comes to grant of bail.
Okay. My next question to you would be around the controversy surrounding, the transfer of Justice Yashwant Parmar from the Delhi High Court to Allahabad High Court and the entire case involving him. But I would like to ask you or get your views on the fact that, do you think the way the entire thing was handled by the former CGI, it was, the videos were uploaded on the website. His response to the complaint made against him was also uploaded on the website, because this has been a major concern amongst the members of the certain section of the legal community, that maybe he was pronounced guilty even before he was tried or heard. So do you think that case was handled practically by the former CGI or not?
See, though I had limited office, I am bound by certain constraints and certain discipline. As far as transfer of Justice Verma is concerned, I was part of the Collegium, where this material was naturally placed before the court. So, specifically dealing with this case, I would avoid commenting. It will be inappropriate on my part.
So then let me just ask you a related question, which is with regard to transfers of High Court judges, because even in Justice Verma's case, we saw that when his transfers order was out, the Bar Association of Allahabad High Court went, they protested against the transfer. And there has been a major complaint with regard to transfer of High Court judges, that it is not a transparent process. No reasons are given. Some transfers are treated as punitive, some are said to be in the interest of better administration of justice. So how do you see this entire controversy surrounding transfer of judges? In fact, of late, in the last 7-8 months, we have actually seen a lot of judges of different high courts being transferred from one high court to the other. Do you think we should have a rational transfer policy for high court judges? Is it needed or not? And if not, then shouldn't the Collegium be coming out more with regard to transfer?
On first point, factually you are right. There have been number of instances of transfer during the last 6 months or so, and especially from me.
Yeah.
We have seen that. And therefore, somebody can, with justification, say that we need to have relook at the whole policy or whole legal mechanism, how it works. Because with the passage of time, we need to have rethink also. The law was laid down, I think, decades back about transfer. So maybe on the judicial side, maybe on the administrative side, it will have to be considered. About that, there should not be any debate.
It should be made more transparent. That's what you
Uh,
believe?
See, transparency is a concept we need to consider it a bit elaborately.
Okay.
Transparency is one thing, but there is also issue of privacy,
Okay.
because if a judge is transferred,
Hmm.
he has to go to other high court and work there.
Hmm.
The litigants must repose faith in him.
Hmm.
So again, it's a debate. If there are some allegations against a judge, whether they should be made public,
Mm-hmm.
because he
Okay.
has to function as a judge there,
Okay.
right? Uh, that is one. Secondly, I mean, transfers can be for various reasons.
Hmm.
There have been instances in the past where the Supreme Court found that there were not enough number of senior judges who have
Yeah.
experience
Yeah.
available in a particular high court for heading the division benches.
Right.
Maybe for a period of time, there are no appointments to that high court.
Right.
I think something happened when that NJSC issue was pending, or
Yes.
for various other reasons also. So some senior judges were transferred to that high court.
Hmm.
That is also one of the grounds. But overall, you are right. I mean, we need to have a relook at it.
Because transfers are often seen as, at least the high court where the judges get transferred, the bar of that particular high court, they get very suspicious about a judge coming into their high court, because it's an outsider. A judge is usually treated as an outsider. In fact, with regard to Delhi High Court, there has been a major angst because a lot of judges from outside have now come to the Delhi High Court and they've become senior compared to those judges who were appointed in the Delhi High Court. And one of the bar members has also written a letter to the Chief Justice. So that is why I mean, there was a time when there was a policy that was followed when judges were appointed, they were transferred out of the parent high court. Do you think, in the interest of justice, this transfer system should be introduced again?
No, transfer system is very much there. That is in place. But as I said, I agreed with you that it needs reconsideration, it needs a relook, so that there is a proper transfer policy in place. I mean, that will have to be done on the judicial side, on the
Or on the
administrative
administrative.
side.
So, coming about transparency, now apart from transfer of judges, the transparency is often spoken about when it comes to appointment of judges in the Supreme Court and the High Court. And all of us know that at present we are following the Collegium system, where a panel of judges of the Supreme Court and the High Court, they nominate the candidates for the High Court and the Supreme Court. Now, it has drawn a lot of criticism for being opaque. What is your view on it?
Now, the entire material is on the website of the Supreme Court. When High Court recommends, Chief Justice and two senior judges recommend, at that stage, the Chief Minister and Governor of the state, they can put in their response. They can say that this candidate is not good,
Right.
or should not have been recommended. Then there is full-fledged IB inquiry. IB works under the central government. And with the views of the Chief Minister and the Governor, IB report, and views of the central government, the files are placed before the Supreme Court Collegium. So at every stage, government has a say. And after Supreme Court Collegium clears it, government has right to send it back for reconsideration. And of course, it is reconsidered and earlier resolution affirmed, then government has to issue order of appointment. So this is the process which is on the website now, and kind of IB inquiry is conducted. You can see it from the website.
Yeah.
Now, people say that process is opaque. Again, issue of privacy comes into picture. I have said it very often. Some successful lawyer accepts the request of the Chief Justice or Senior Justice of that High Court and says, I am willing to accept the post. Either the High Court Collegium and even the Supreme Court Collegium will consider cases of every candidate. If they consider 10 candidates, they may clear 3 candidates, for example. About 7 candidates, if they say that no, he is not competent enough, or there is issue of his integrity, or his income is too low, and if it is made public, the privacy of that candidate is also affected. In the sense, he has to go back and practice. So issue of privacy of that candidate, because you know when you accept the request, you answer the call of the nation, call of the duty.
Mm-hmm.
So slightly differently these lawyers have to be treated,
Mm-hmm.
because there are many cases you will find that very successful lawyers say yes. Idea is to answer the call of duty. So even that aspect needs consideration. For example, in some cases, Supreme Court Collegium recommendations were put on the website. Even the average income of that lawyer is mentioned in
Okay.
that particular resolution.
Okay.
So privacy comes into picture.
Okay. So are you suggesting that the resolutions which started coming on the Supreme Court website, where all the details were made public, do you think that was incorrect then? It should not have been done?
The
Or
privacy aspect needs to be considered. See, ultimately, it has correlation with something else.
so how can one really strike a balance?
That will have to be considered. That
Yeah.
will have to be considered, because today some lawyer is made aware that his entire thing, what is his income, what are the drawbacks in his personality or etc., are to be made public. He may not give consent also. Even that aspect also needs to be kept in mind.
So then
So it has to be balanced. So what I personally feel is, only by publishing resolutions on the website, you don't bring in transparency. Transparency has to be in basic process.
Yeah, okay.
Right.
Okay.
That's the crux of it.
So the basic process should be made more transparent.
Right.
Okay.
In the sense, how many candidates you are considering, how you are finding out the candidates, in what manner you are considering, that is more important.
Do you think the present system, developed by the Collegium of interviewing the candidates before they finalize the appointments to High Court, do you think that is a positive development?
I mean, it's a very difficult question to answer, because I think we need a lot of debate on this.
Okay.
Lot of debate on this.
Okay.
See, so long as Supreme Court Collegium is not taking decisions only on the basis of interaction, there is nothing wrong with that, so that Supreme Court Collegium judges see the candidate, they interact with him. But if it is converted into interview, there may be some issue, in the sense that, you know, we are human beings. So some day may be bad day for you.
Okay. Okay.
Then it may be a bad day for that candidate. He will keep on searching for words. He may not perform properly. It happens to everybody. So if it is converted into interview and decision is taken only on the basis of interview, then something can be said about it. So we have to actually consider what is the nature of interaction, how much weightage is given to interaction. That's the crux of the matter. And that I don't know, because I was not party to any such thing.
Okay. So, appointment to the Supreme Court has always been, in some way or the other, it has always drawn some sort of controversy. It could be for various reasons. Could be for one candidate superseding many judges, somebody, coming from a high court where you already have many judges in the Supreme Court. So when it comes to appointment to the Supreme Court, we all understand that Supreme Court has a very limited pool, whereas we can have many candidates or many people, who may be eligible for elevation to the Supreme Court. So how can one really make sure that no controversy arises out of these appointments?
In lighter vein, I don't think that anybody is capable of avoiding these controversies. It's impossible to avoid controversies, because it is such an important post, right? But, we keep on hearing that there has to be diversity. When you talk about diversity, it is not only in terms of caste and religion or minority groups. It is about the region also. Because our country is such a huge country, and different states have different cultures, so every state must get representation. So it's a combination. When we talk about diversity, it's a combination of all the factors. And if you say that diversity has to be there, you can't look only at the All India seniority.
Okay.
See, there are judges of the high courts who have been judges for 16 years. They have retired without even becoming chief justice of the high court.
Okay.
Because we look at the regional representation.
Okay.
Right.
So seniority cannot just be the only criteria to come to the Supreme Court.
I don't think, I personally, it can't be the criteria, because when I went to Supreme Court, there may be 7 or 8 judges who are junior to me in All India seniority, but I can't find fault with them because they were representing that state.
Okay.
Maybe somebody is representing a minority community.
Got it. Yeah. So
Right.
it has to be diverse representation.
Diverse representation, and then you can't go by seniority.
Senior. Got it, sir.
And it's a Hobson choice. If you follow seniority, then you will say that diversity is not being followed.
Yes.
And then if you look at diversity, then you say now seniority is bypassed. See, ultimately, I'll tell you, crux of the matter is the quality of the person who is considered for appointment to the Supreme Court. Quality is the most important.
Is the most important.
Most
yeah.
important.
So
Quality, caliber, integrity.
Yeah. My
and
last
capacity.
question is with regard to, again, an often spoken about concern is, the government's pick and choose policy when it comes to appointments. All of us know when a resolution is forwarded or when a recommendation is made by the Supreme Court, the government is supposed to honor all of them in one single batch. But we have seen in the past that they have, they have kind of given priority to certain candidates, whereas they have left behind some. How do you see this process impacting those who really are keen to get elevated to the bench? Do you think it discourages better quality of lawyers from opting to become judges?
Now, we know what is the process. At every stage, government has a say. We can find out from the Supreme Court website. And therefore, it is but natural that when Supreme Court recommends, decision has to be taken as expeditiously as possible. And government has option open as per the judgment of the Supreme Court to send back the case for reconsideration. And after it is reconsidered and reaffirmed, government has to appoint. This delay causes a lot of difficulties. I'll tell you what is the difficulty. A successful lawyer gives consent for being appointed a judge of the High Court. When I became judge, no resolution was being uploaded on the website. So there could be some kind of a secrecy. Now today, if the resolution of Supreme Court goes on the website, and thereafter it takes 9 months or 10 months or even some cases, in case of even good judges, it has taken more than 1 year. Naturally, when the resolution is seen on the website, why would a briefing lawyer or litigant will go to that lawyer and give him cases? Because he will feel that now no purpose is served by giving him case and paying him money.
Yeah.
So this is a practical difficulty. Once name is published in the resolution of the Supreme Court, virtually practice stops. Now, can you survive? Everybody has his family. Can you survive without reasonable practice for this period of 2 months, 3 months, 4 months, or 6 months?
Okay.
And this uncertainty is the real factor which discourages some of the successful lawyers from saying yes.
Okay.
So this is a practical difficulty.
Got it.
Because any process, you don't require, intricacies of law to be gone into. It has to be done expeditiously. When you have a process which is laid down by a judgment, it has to be done expeditiously.
Of which the government is a very, very much part of it at every
part
stage.
Part of it, right, correct.
Yeah, okay. Thank you so much, sir, for joining us and having a very candid conversation about your journey as well as about your experiences in the judiciary. Thank you so much.
Thank you.
Thank you.